Hello viewers, today we will try to discuss a very important aspect of intellectual property rights. The topic for this particular lesson is copyright protection and emerging issues. Copyright, as everyone knows, is one of the oldest forms of intellectual property rights, and of late it has been facing certain technological advancements and also the legal developments related challenges, and the copyright may be claimed by the creator or the author if any modicum of creativity in the work can be proved. The copyright protection has two objectives, namely to provide economic incentive to the author and to promote dissemination of information. Each of these two rights is exclusive to the author, and such rights have been guaranteed under various international and national laws. In recent times, the stakeholders in the copyright in respect of the works have been facing a variety of issues and challenges. They include demand for copyleft, protection of celebrity rights, claims of copyright in sporting events, preservation of traditional cultural expressions, and more particularly the issues of piracy. The emergence of remix culture and use of artificial intelligence also made the traditional copyright protection a complex issue. Each of the above issues is unique, as the purpose and objective of such issues varies from one context to the other. In this lesson, we shall try to understand some of these pressing issues and challenges in detail. First, let us start with the copyright protection in the digital age. It is known that copyright protection was originally introduced as a response to the evolution of print media in the 15th century. However, the advent of digital age in the 20th and 21st centuries has challenged the traditional legal framework of the copyright law. Today, the world is witnessing convenient use of technology and the World Wide Web, which are facilitating replication, modification and transmission of information at different levels. Consequently, certain movements like open access movement and also free culture movement have emerged. For instance, the question arises as to the justification of producing remixes and mashups as an exception to copyright protection and by way of fair use. Due to cumulative use of digital media, it is felt that the existing legal framework of copyright protection does not fit the digital age. Remix, which is a mixture of pre-existing work, though cannot be described as original, but certain advocates like Lawrence Lessig believe that remixing is a creation out of prior work. Similarly, mashup also is believed to be a work of remix. Another consequence of digital age is the emergence of the system of openness. Persons like Peter Drucker and Alvin Toffler in the 1970s and Lawrence Lessig in the first decade of the present century have contributed to free culture movement and certain new concepts like Creative Commons. The remixes and mashups prima facie appear to be infringement of the right of reproduction as recognized by Article 9 of the Berne Convention and Section 14 of the Copyright Act 1957. However, the Court of Justice of the European Union in the case of Eva Maria Painer decided in 2011 held that the reproduction is lawful if due credit is given to the author by indicating his name in the reproduced segment. In the Indian context, version recordings which were considered as instances of fair use under section 52 clause 1 subclause J of the Copyright Act before its amendment in the year 2012 were held to be lawful subject to certain conditions. One may recollect the decision of Hum Aapke Hai Kaun case, where it was held that version recordings do not violate copyright. It is also equally relevant to mention that by way of 2012 amendment, the statutory licenses in respect of such version recordings cannot be obtained so easily as before, since the number of copies of such version recordings should be minimum 50,000 and the producer of such recordings should wait for minimum 5 years after the release of the original musical work. The amendment comes in the form of a new section 31C under the title Statutory License for Cover Versions. It is for the first time that the cover version is being used till date, and the copyright has never used either version recording or cover version before. The possible implication of this amendment is that for the first time cover versions are recognized under a statutory licensing framework and not merely as a defense to an infringement of copyright, that is section 52(1) J of the Act. In 1994, Steve Jobs, the founder of Apple, was asked in an interview whether he had stolen the idea of graphic user interface GUI for Xerox. He famously quipped, "Picasso had a saying, good artists copy, great artists steal." Apparently, Picasso practiced what he preached. Pablo may have borrowed the phrase from the Russian conductor Igor Stravinsky, who once said, "Lesser artists borrow, greater artists steal." Mr. Stravinsky, an appreciator of the arts, clearly had T.S. Eliot in mind, who in turn had once stated, "Immature poets imitate, mature poets steal." This may have been influenced by an article written by W.H. Davenport, who almost comically enough was referring to the poet Alfred Tennyson, who according to Davenport constructed his verses using the efforts of his artistic antecedents as a resource. When he wrote in 1892 that great poets imitate and improve, whereas small one steals and spoils. Now, coming to the copyleft. Copyleft is a strategy of utilizing copyright law to pursue the policy goal of fostering and encouraging the equal and inalienable right to copy, share, modify and improve creative works of authorship. Copyleft as a concept is usually implemented in the details of a specific copyright license, such as the GNU General Public License GPL and the Creative Commons Attribution Share Alike license. Copyright holders of creative works can unilaterally choose these licenses for their own works to build communities that collaboratively share and improve those copylefted creative works. Copyleft.org is a collaborative project to create and disseminate useful information, tutorial material and new policy ideas regarding all forms of copyleft licensing. This site itself is licensed under a copyleft license and has contributions from experts around the world. Creative Commons. Creative Commons project was originally created in December 2002. Since then, more than 50 countries have joined this initiative and more than 500 million works have been licensed under Creative Commons. The Creative Commons project is co-managed in Brazil by the ITS, that is the Institute for Technology and Society, and Fundacao Getulio Vargas. There are 6 main Creative Commons licenses creatives can use when publishing their work under the CC terms. They are: 1. Attribution CC BY. This license lets others distribute, remix, tweak and build upon the work even commercially, as long as credit is given for the original creation. This is the most accommodating of licenses offered, recommended for maximum dissemination and use of licensed materials. 2. Attribution Share Alike CC BY SA. This license lets others remix, tweak and build upon the work even for commercial purposes, as long as they credit the work and license their new creations under the identical terms. This license is often compared to copyleft free and open source software licenses. All new works based on the work will carry the same license, so any derivatives will also allow commercial use. This is the license used by Wikipedia and is recommended for materials that would benefit from incorporating content from Wikipedia and similarly licensed projects. 3. Attribution No Derives. This license lets others reuse the work for any purpose, including commercially. However, it cannot be shared with others in adapted form and credit must be provided to the original author. 4. Attribution Non-Commercial. This license lets others remix, tweak and build upon the work non-commercially, and although their new works must also acknowledge the original author and be non-commercial, they do not have to license their derivative works on the same terms. 5. Attribution Non-Commercial Share Alike. This license lets others remix, tweak and build upon the work non-commercially, as long as credit is given and the new creations are licensed under the identical terms. 6. Attribution Non-Commercial No Derivatives. This license is the most restrictive of the 6 main licenses, only allowing others to download the works and share them with others as long as the credit is given, but the work can't be changed in any way or used commercially. Thus, it could be seen that we are shifting from the copyright regime of all rights reserved to some rights reserved in the digital arena particularly. Very interesting development in recent times has been a phase which can be called Picasso to Picasso. In the good old days and even till now, it is only the human beings who created literary and artistic works, though the copyright in respect of them could be claimed by humans as well as legal persons. Of late, a new trend appears to be emerging. Even animals and machines are also creating certain works in the nature of literary and artistic works. It happened in the case of monkey's selfie case. The facts of this case are that a British nature photographer, David Slater, had travelled to Indonesia since 2008 to take photographs of the critically endangered Celebes crested macaques, also called black apes. In 2011, he licensed several images which are the self portraits taken by the monkeys. We can also call them monkey selfies, which were published in magazines, and the photographer claimed copyright in them. Then People for the Ethical Treatment of Animals, PETA, an American animal rights organization based in Virginia, filed a suit in an American district court claiming violation of copyright of the monkey the Federal Ninth Circuit Court held that a non-human being cannot hold copyright. In another very interesting case involving a piglet named Picasso, the painting pig, which was rescued from an industrialized hog farm in South Africa, it was found that the pig indeed painted certain beautiful pictures. Some of the paintings were even purchased by the Swiss Airlines. The question that arises is as to the ownership of the copyright in paintings. Though no litigation appears to have been filed in this case, the issue still remains to be addressed. Similarly, the questions relating to the literary works and paintings made by the computer program also, whether driven by artificial intelligence or otherwise, pose certain challenges to the established notions of ownership of copyright. Projects such as Deep Dream, a program that uses neural networks to produce new visuals, let anyone use artificial intelligence approaches to generate ostensibly art. In a 2016 charity auction in San Francisco, prints made by using Deep Dream were sold for as high as $8,000, raising questions about whether the uploader or the algorithms should get credit. The same thing can be said in case of any works if created by Sophia, the humanoid robot, Siri and Alexa. Probably a new jurisprudence needs to be created in such cases. Now, another important issue is with regard to traditional cultural expressions which are in the public domain for many years, probably for many centuries. The World Intellectual Property Organization, WIPO, states that traditional cultural expressions, also called expressions of folklore, may include music, dance, art, designs, names, signs and symbols, performances, ceremonies, architectural forms, handicrafts and narratives or many other artistic or cultural expressions. Because these traditional cultural expressions raise some particular legal and policy questions in intellectual property, they receive a distinct focus in many national and regional intellectual property laws and in World Intellectual Property Organization's work. The traditional cultural expressions can sometimes be protected by existing systems such as copyright and related rights, geographical indications, appellations of origin and trademarks. For example, contemporary adaptations of folklore are copyrightable, while performances of traditional songs and music may come under the WIPO Performances and Phonograms Treaty and the Beijing Treaty on Audiovisual Performances. The WIPO's Intergovernmental Committee on Intellectual Property and Genetic Resources, Traditional Knowledge and Folklore is negotiating international legal protection of traditional cultural expressions. The possible issues relating to this could be identification of stakeholders, their documentation, exercise of economic and moral rights by the stakeholders and undue commercial exploitation of the traditional cultural expressions by unrelated companies and individuals. Another interesting aspect of the emerging issues in copyright protection is in the form of Google Books case and also the Delhi University's photocopying case. As we know, the purpose of copyright protection is not only to incentivize the authors and owners, but also to serve the larger public interest through dissemination of knowledge and information. Probably this is the reason why so many exceptions have been added under the caption fair use or fair dealing, which constitute a very good defense in challenges for infringement of copyright. However, sometimes giving access to the published and copyrighted works, especially the books, to those who are not having license or permission to use them, particularly when the purpose is not to violate the economic rights of the publishers, but only to pass on more and more information to the users. And the purpose of such accessibility is to enhance and to provide greater access to affordable knowledge and resources to the users. With this objective, Google had come out in 2004 with the library project, under which it collaborated with major libraries, collected their books and scanned them into a machine readable format. For this, Google did not obtain permission from the authors of the books. The readers were given facility to search for the relevant terms they wanted to search for by the help of snippet, that is only certain portion of the book, which constituted not more than 16% of the total book related with the search, and Google would display the books which contained the search words along with the information regarding the purchase of that book. Further, Google permitted the concerned libraries to download a scanned copy of the book, subject to the condition that copyright laws should be respected. In 2005, Authors Guild and number of individual authors filed a suit against Google containing that scanning the complete book and displaying it through snippets would constitute substitution of the work rather than its transformation, and further that since Google acts like a commercial entity, it cannot take the fair use shield. The Second Circuit Court affirmed the decision of the lower court, declaring that the service offered would amount to fair use, since it was for expansion of the knowledge. The court relied upon factors like the purpose and character of the use, the nature of copyrighted work, the amount of substantiality of the portion used, and the effect of use on potential market. This decision drew criticism from many publishers and authors. Coming back to India, in the Delhi University photocopy case, a photocopying or Xerox center on the Delhi University campus along with the Delhi University were sued by many international publishers, including Oxford University Press, for photocopying course packs, that is relevant pages on a given topic from different books at a subsidized rate. In this case also, the permission of the authors and publishers was not taken by either the university or the Xerox center. The Delhi High Court in the instant case ruled that photocopying and supplying such course packs does not amount to infringement of copyright, and that it amounts to fair use. The fact that no appeals were filed against the judgment and the solitary appeal was forced to be withdrawn shows that final word in India at least is yet to emerge. The above two cases demonstrate the emerging conflicts between copyright and fair use, and probably the courts have to take a call to settle this issue once and for all. Celebrity rights and personal branding. The celebrities have certain unique rights due to their popularity. Their appearance, name, voice, mannerism, etc. may be the subject matter of imitation by many. It may be sometimes even for commercial purposes. The question that arises is whether such celebrities have any copyright or other kinds of intellectual property rights. In Fortune Films International versus Devanand, the Supreme Court of India stated that an actor in a film has no rights over his performance in the film. However, this position changed in 1994 with the amendment to the Copyright Act 1957, extending recognition to performers' rights with the inclusion of sections 38 and 39. Now, section 2QQ of Indian Copyright Act 1957 defines a performer as someone including an actor, singer, musician, dancer, acrobat, juggler, conjurer, snake charmer, a person delivering a lecture, or any other person who makes a performance. And performance as any visual or acoustic presentation made live by one or more performers. The Delhi High Court in Neha Bhasin versus Anand Raj Anand, addressing the question of what would constitute live performance, observed that every performance has to be live in the first instance, whether it is before an audience or in a studio. If this performance is recorded and thereafter exploited without the permission of the performer, then the performer's right is infringed. In the famous case of Martin Luther King Jr. Center for Social Change versus American Heritage Products Inc., the word celebrity was defined from the legal point of view, and right was extended to public figures like Martin Luther King Jr. too, which was earlier extended only to professional athletes, comedians, actors and actresses and other entertainers. Today, anyone who has reached a state of prominence or is yet to reach prominence in the society and seeks to gain public attention by their acts can be called as a celebrity. In India, the authoritative precedent or a concrete legislative measure is awaited as to the IPRs, more particularly the copyright and performance rights of the celebrities. Now, coming to the copyright in sporting events, the important issue is whether the sports enthusiasts from India can get access to the benefit of live telecast of the games and sports played in India and involving the games of national importance. In Union of India versus Board of Control for Cricket in India, the Supreme Court held that the sports broadcasting signals mandatory sharing with Prasara Bharati Act 2007 mandates sharing of the live broadcasting signals of sporting events of national importance with the Prasara Bharati, which owns the erstwhile Doordarshan's channels networks for retransmission of the same through its terrestrial and direct to home networks. The court further observed that the live feed received by Prasara Bharati from content rights owners or holders is the only for the purpose of retransmission of the said signals on its own terrestrial and DTH networks and not to cable operators, so as to enable the cable TV operators to reach such consumers who have already subscribed to a cable network. This issue also could be one of the emerging issues given the involvement of large stakes involved and the right to use of free electronic waves being a fundamental freedom. To conclude, we can say that in view of some of the pressing issues as discussed above, it is in the interest of all those concerned with the IPRs in general and copyright in particular to focus on such issues, so that the air is cleared and any kind of ambiguity is avoided in interpretation and implementation of the law. The time has come to clearly distinguish copyright from copyleft and also copyright from copy wrong. I sincerely hope that this lesson has cleared many doubts that may be plaguing the viewer's mind, and we shall meet in the next lesson. Thank you.